Obamacare makes another appearance before the Supreme Court. I'm Stephanie Shabazz, and this is Scholars Mate. Hello and welcome to Scholars Mate. I'm your host, Stephanie Shabazz. Joining us today are Robert Destro of Catholic University and Robert Weiner of Arnold and Porter. Welcome, gentlemen.
Thank you. Thanks for having us.
Absolutely. Well, the Supreme Court recently heard another case concerning the Affordable Care Act, also known as Obamacare. For an explanation of the case, who better than Jon Stewart of The Daily Show?
It turns out that the Affordable Care Act provided federal tax credit subsidies to qualified lower-income individuals who signed up in exchanges established by the states. But as you know, 36 states, the redder ones, opted to not set up those exchanges, forcing their residents onto federal exchanges, which caused a lawsuit and thus...
The law doesn't expressly say people who get their insurance through federal exchanges also get those tax credits.
See, the law says you must be enrolled in through an exchange established by the state. Now, a normal person might say, do you really think the law intended subsidies only for lower income citizens of states that weren't being dicks about the exchanges? Well, 2 of the 3 judges in this instance said, yeah, we have to take that sentence literally. I'm just happy both judges got to work that morning, assuming that once they hit stop signs, their day ends.
So, Robert Destro, you wrote a brief in this case. Why should the court rule that subsidies through the federal exchange are illegal?
Well, the case really is about money, so it's good that you started with subsidies.
Right.
And you know the rule, which is basically follow the money.
Right.
And so if you follow the money through the system in this case, what you'll see is that Congress set up the Affordable Care Act so that everybody got subsidies. The states got subsidies, individuals got subsidies, hospitals got subsidies, everybody got subsidies. And Congress counted on the states to pull part of that weight. And so they put a lot of money up front to get the states to set up exchanges, but then they put some conditions on it. Like, you know, if you don't set up if you set up an exchange, you have to bear the cost of running it. Okay. Well, the big condition in this case is that if you're in a state that has not set up an exchange, then under the plain exact language of the statute, you're not entitled to a subsidy for your health insurance. And that's the problem in this case.
So can you elaborate a little bit more on that, Mr. Weiner?
Yeah, I think the plain exact language of the statute doesn't say what Mr. Destro plainly and exactly says it says. The language of the statute uses defined terms. Congress can define a dog as a cat if it wants to. Here it defined the terms, and it defined an exchange, which is the marketplace in states, as an exchange established by a state. And then it said, and it told states they have to establish an exchange. It defines the word exchange. And then it says, if a state doesn't establish an exchange, the secretary has to establish such exchange. Which exchange? The only one that's defined in the statute, which is an exchange established by the state. So how does the Secretary of HHS establish an exchange that is defined, there's a definition, as an exchange established by the state? And that's impossible. How could you do that? Well, the only way you could do that is by stepping into the shoes of the state, by acting as a surrogate or a proxy or an agent or all the other kinds of words that we have in the law that describe that kind of relationship. So this is not as simple as or as plain as Mr. Destro would have it characterized. It is an example of Congress using defined terms to accomplish what is clearly and plainly the purpose of the statute, which is stated over and over and over again to provide affordable care to all Americans, not Americans in some states, all Americans. That word all is not a limiting word.
So how do you respond to that, Mr. Destro? Because in his perspective, it sounds like it's not as limiting as you're making it sound. So what do you say to that?
Well, that's why I said that you need to follow the money. I mean, the language of the statute is very clear that in order to get a subsidy, you need to buy it on an exchange established by the state. Now, Mr. Weiner's argument is actually quite a good argument, and it can be persuasive. But if you get into the fine print, you find out that other things are tied to the fact that a state establishes an exchange. For example, the employer mandate and the individual mandate. If I live in a state in which there are no subsidies, then I'm not subject to the individual mandate, nor is my employer subject to the individual mandate. So if it were just about affordable health care for individuals, then Mr. Weiner makes a very good argument. But if it's about how do we provide affordable health care without bankrupting the federal government, then it's a very different question, because now the states are not active players in the process. So, and I'm not an active player in the process if I don't have to have an individual policy. So all of this is very finely tuned and fits together and depends on everybody playing their role. And what they didn't anticipate back when they wrote the statute is that the states were going to say no.
And I would say that's simply incorrect. I mean, Congress provided for a fallback exchange. Why would you provide for a fallback exchange if you expected all the states were going to participate? I mean, and you certainly wouldn't provide a fallback exchange that is doomed to failure. Now, if the premise was that all this was going to fit together and this was exactly the way it was going to be done, that there would be no exchanges in state, there would be no subsidies in states that didn't have a federal exchange, you would expect that somebody in the extensive debate of the statute would have said so. In fact, you would expect that that the red states, the ones who are not going to get subsidies here, the red states, you would expect they would have yelled and screamed that they were being discriminated against in the legislative process. That didn't happen. Instead, what you have here is a reading of the statute that no one discovered until 10 months after the statute passed. That's not fitting together. That's stealth. And there is a canon of federalism that you don't impose stealth conditions on states. No surprises. You want to impose conditions on states, you tell them. You tell them clearly. The statute doesn't say that at all, much less clearly.
Well, I mean, to say that it was stealth is I think, stretching the point. I mean, this is a 2,500 plus page statute that we're talking about. It was written behind closed doors in Harry Reid's office, and so there wasn't a big debate about it.
Closed doors.
It really was. I mean, there were no markups, there were no committee hearings. This thing was rammed through into law because they were afraid that they wouldn't have enough votes. And so what happens is, and people finally read it, you saw Nancy Pelosi say, you have to read the bill, you have to pass the bill in order to find out what's in it. Well, what happens when you do something this quickly is mistakes get made. And I think this is one of those mistakes. And to say that the federal government, that people wouldn't get subsidies in the territories, there's no subsidies. And those are federal exchanges. So the idea that Congress was very much aware that it wanted individuals and it wanted businesses and it wanted the states as well as the federal government putting money into this kitty. And when the states withdrew, they took with them the individuals who are subject to the mandate and the businesses that are subject to the mandate. And that's why this thing, if it plays out exactly the way the parade of horribles they're talking about, that's why it'll fail, because Congress assumed that it can compel the states. The Supreme Court told them they couldn't do that. It thought that they could compel the individuals. they can do that through the tax code. So there was no stealth here. Everybody knew exactly what was in that bill. And in fact, HHS, the Department of Health and Human Services, when it started healthcare.gov, it never put a subsidy calculator in it. So they were kind of assuming that there were no federal subsidies either.
And that's just, there's a number of things that aren't right about that. First of all, there was more debate on this bill than I think almost any bill in history. There were weeks and weeks of markups. They're public. You can go read it. And, when you do, you'll find that there's no mention of this issue about states not getting subsidies. You will find in this case a brief by 22 states that amounts to, the brief is a long way of saying, say what? We're not getting subsidies? They were surprised. Nobody read the statute this way until 10 months after it was adopted. And the territories, by the way, is a red herring. You know why there's no tax? This is all through the tax code. There's no tax subsidies in the territories because almost no one in the territories pays federal taxes. So that's why they didn't put taxes in these subsidies in the territories. They defined the territory as a state in order for the territories to be subject to the act at all. Otherwise, they wouldn't have been. So this was a reading of the statute that was discovered and announced at an American Enterprise Institute conservative think tank conference 10 months or so after the statute passed, pursuant to an instruction to find some way to kill Obamacare as a matter of, and I quote, political hygiene.
So with that perspective, I want to get right to some of our questions from our viewers as we have some of them pouring in. So this is from one of our viewers, Melvin Ryan, and he's saying, is it the Supreme Court's job to bail out Congress for poorly written legislation? Mr. Destro.
Absolutely not. In fact, this is really democracy at work. I mean, that if the Supreme Court holds that the subsidies are illegal, we're going to have a huge debate in Congress. We're going to have a huge debate between Congress and the president, and we're also going to have a huge debate in the states. And that's the part that I think many people don't understand, is that Obamacare will survive as is right now in the 16 states that have exchanges, and in the 34 states that don't. All they have to do is create a state exchange, even if it's run by the federal government, because they can't get it up and running in time, and they get their subsidies. So the whole question is going to be about the subsidy policy itself, and there will be a debate about that.
Your perspective, Mr. Weiner?
Well, I think what you have here is an effort to subvert democracy. We have a bill that was passed by a substantial majority in the Senate. It was passed by the House. It was signed by the president. Those are the people that we elect to make these laws. And now you have 5 years now of litigation that is designed to gut the statute. The minute the constitutional litigation was brought 7 minutes after the bill was signed. When they lost that, they tried this tactic. The statute, could it be written better? Yes, it could be written better. Can you give it a reasonable reading that is consistent with what everybody who was involved says Congress intended? Yes, you can give it a reasonable reading. This is not a situation where it says states who don't have exchanges don't get subsidies. That would have been clear. Doesn't say that. And the court needs to implement what the statute as a whole clearly expresses as its intent.
So I have another question I'll direct also to you, Mr. Weiner, from Terry Foster. And she says, if Congress intended to limit subsidies up to the state exchanges, then why didn't that point come up when state legislatures were debating whether to set up their own exchanges?
Well, that gets to the federalism issue. I mean, you had these 22 states who said, we didn't know. You had 6 states that said some variation of we did know. But when you go and look at the record and you see them debating whether to establish the exchanges, the record establishes that they didn't. They were talking all about, in fact, you had ALEC, which is a conservative organization that services state legislatures, and it was saying there really is no difference between a state exchange and a federal exchange, or there's no penalty for doing this. And so it was not clear, and one thing the Supreme Court has made very clear, and that clearly troubled Justice Kennedy in this case, was that the states weren't aware of this. It wasn't plainly expressed. It wasn't in the part of the statute that talks about what the state's obligations are. It wasn't really clearly expressed in the section of the statute that says who's eligible for subsidies. Where does the language appear? And how you calculate the amount of the subsidies. That's not clarity.
Your response, Mr. Destro?
Well, this is again one of those problems where, you know, the old adage, if all else fails, read the directions. I mean, this is one of those cases where, of course, when the states were debating whether or not to set up exchanges, much of that discussion was going to be how much does it cost, what does it cover, who participates, all those kinds of things. You know, but they weren't, the state governments were thinking about how is this going to impact them, okay? And they were the first responders on this. In the subsidy question with respect to when, you know, as Mr. Weiner quite accurately pointed out, the ink was barely dry on the Affordable Care Act before the first lawsuit came. Well, that's because Congress was compelling the states and individuals to participate, and nobody likes to be compelled. And as the late Justice Robert Jackson, who was FDR's, you know, Attorney General, used to say, he says, constitutional litigation is power politics by other means. That's what we're talking about here. And so the question then becomes, it's not just about the states, it's not just about the people who want to get subsidies, it's also about the individuals who don't want to buy insurance and get a tax penalty. That's who King is. That's who the plaintiffs are. They say we shouldn't be subject to the mandate because the people in our state aren't eligible for the subsidy. That's the discussion here.
Interesting. We also have another question from a viewer. His name is Anthony Watkins, and he said this, and I'll direct it to you, Mr. Destro. If we can divine the original intent of the Founding Fathers 200 years ago, why can't we divine the original intent of Congress 5 years ago?
That's a great question. And I think I'm going to tie the two things together. If there was one thing that was really clear about the Founding Fathers, it was that Congress, particularly the House of Representatives, was in charge of the money. You know, because that was the whole idea that the Congress alone should be in charge of deciding who gets money and who doesn't. And that's why I started out this question of what does the statute say about who gets the money? And in the tax code, which is the one that is Justice Roberts held, Chief Justice Roberts held, is that which binds you to the mandate. It says an exchange established by the state. It doesn't say established by proxy by the state. You know, none of the state of Virginia certainly didn't hire the federal government to do it for them. They could have, you know, but they didn't do that. So the intent of Congress, all we have on the intent of Congress is the language they use. That's a Justice Scalia argument, I might add. I mean, it's what they said, not what the body as a whole, getting in a Quaker sense of the meeting sense, intended. It's what they said.
No, I know you have a strong response to this.
Sure. Well,
What's your perspective on this?
Let's talk about the language of the statute then, because that's all. This isn't a question about whether we're talking about implementing the broad purposes of the statute in derogation of the statutory language. This is where we're looking at the statute and looking at the context of the statute.
Right.
One of the things it says is over and over and over again is affordable care for all Americans. All. You know, that is a clear expression of congressional intent. Now, to say that you got to follow the money and the IRS doesn't have the power to direct the money assumes the conclusion, assumes that the statute says that you can only get subsidies on an exchange established by the state. But Congress, it is a language trick. It is a sleight of hand to say, we're going to tell people this is the way we should understand it, because this is the way we understand it in ordinary English. Well, okay, but Congress defined the terms. And Congress defined the terms in a way that it said that the Secretary of HHS has to establish an exchange established by the state. And, you can just do the math and transitivity and all of that. That is the intent of Congress. And it's consistent with the rest of the statute. For example, if you don't say that the Secretary can stand in the shoes of the state, then there's nobody to buy on an exchange, because a qualified person is defined as a person who buys on the exchange, who's a resident of the state that established the exchange. Well, if you say that that means that the state, that this provision requiring the Secretary to step into the shoes of the state isn't operative, then there are no qualified people. You have an exchange with nobody on it. That, you can make a lot of statements about Congress, but when we interpret statutes, we assume that Congress acted rationally.
Great. Now, it's time for Answer This, where each guest gets to ask questions directly to each other. Mr. Weiner, would you like to go first?
Sure. This is like picking which one is really tough here.
There's so many.
If Congress wanted to encourage states or threaten them, why didn't anyone ever say that in debates?
Because, well, I think the short answer to that is that we didn't really get a debate about the detail of this statute. And to say that anybody was surprised, I mean, that the majority party in the Senate, put all this language in, and now it's a little late to be saying this is a little bit like, murdering your parents and then throwing yourself on the mercy of the court as an orphan. That this is it's like, look, we were surprised. Who was surprised? You guys wrote it. So there's no surprise here. It's just they didn't catch it. And a mistake was made, and a big one. And I think Mr. Weiner is wrong when he says that an exchange established by the state is not the same thing. If it says an exchange established by Mr. Weiner, and then I do it, it's not an exchange established by Mr. Weiner. It might be such exchange, but it is not Mr. Weiner's exchange. And those are the kinds of questions that come up here, and it makes this case tough.
So, Mr. Destro, now a question again from you for Mr. Weiner.
Well, let's get into this question of people losing their insurance. I mean, I think that you still haven't really answered the question, what would you do? You don't think it's going to happen. But would you support, for example, allowing people to literally just go shop for insurance the same way they do for car insurance, house insurance, boat insurance? In fact, you could see flow from Progressive, selling insurance. I mean, what would be wrong with that? Because the original idea was that these exchanges were going to be like Amazon, and that we were going to be able to just go shop. Now what the federal government has done is said, you have to buy this package. Everybody has to buy this package. And that's what's driving, that's why things will go up 35% without a subsidy. So, I mean, what would you let people shop on their own?
So what I would recommend to Congress, if the court decided against them, was that they rewrite this provision so that it is clear that people get subsidies in all the states. I think that the exchange is supposed to work like Amazon or really Travelocity, okay, where you can compare policies and buy the one that's advantageous to you.
All right, and now it's time for We Agree. where each guest names something the other said that he agrees with. Mr. Weiner, we'll have you start with this one.
I'm working here.
I know.
Well, I think that, why don't you let him
If you
go
can
first?
find something.
Why don't you let
Mr.
him go
Destro,
first?
I'll have you. He's searching.
Well, one of the things that I agree with is that Congress is going to have to go back and debate these subsidies. How much, what they're willing to subsidize, and if they're still willing to subsidize state exchanges after this. I mean, so that's why I started out my comments that this case is about money. And to say that you're perverting democracy by sending it back to Congress and having to have a do-over, that's not perverting democracy. That's the way the Constitution is written. And the same thing is true in the states. Let them debate this. But look at how many, I don't know the exact number, but look at all the numbers of members of Congress who lost their seats over Obamacare. That was a democratic process too, and I think that the fact that both the White House and the Congress are afraid of this case means that the rest of us should be very happy that we're finally going to get a big debate.
So where we agree is that we both think that the decision on health care should lie with our elected representatives. We part company because I think that what's going on here is an effort to get a do-over through the judicial process. We had a debate. We had a vote. We had a president who ran on health care, and he got elected. The democratic process has spoken. And to try to use the courts as an effort to relitigate, re-argue what was argued in Congress is not the democratic process we should have. It's not the democratic process we used to have. Just because Congress is dysfunctional doesn't mean that we should go to the courts and let them take over that function. I think when we do that, we lose democratic rights that are very important to all of us.
Excellent. All right, so that's all we have time for. Thanks so much for watching Scholars Meet, and we'll see you next time.